Good morning, everyone. This is Ann Gambardella at the Virginia Auto Dealers Association. It's 10:01 now, so we're going to go ahead and get started. We know we still have some folks joining us. Wanted to welcome you today to our 2025 legislative and legal update. I am joined today by Barrie Beaty, our outside counsel, and then also Mimi Perka, who is a newer attorney on our staff, and we're going to go over some important legislative and legal topics for you today. Um, it's been a busy year at the General Assembly. We're going to go through the legislative pretty quickly this morning so we can get to some legal topics. There is obviously the warranty compensation bill. We did a buyer's order bill for leases, some consumer related bills and employer related bills. On the warranty compensation bill that Mimi's going to review in just a few minutes. I wanted to make sure that you all knew that we put together a podcast with our partners at Armadas to go over that bill as well. So that's on the website as an additional tool for you in looking at that legislation. And then we're going to also talk about under some legal issues, building sales and F&I compliance, franchise issues, and personnel practices. Talk a bunch about advertising as well. Most of you all are pretty familiar with our legislative team at this point. These are all familiar faces to you. Wanted to do a big shout out to our legislative chair, Tim Pohanka, and also our chairman of our board of directors, Dan Bannister, who were very instrumental in helping us during the legislative session this year. Obviously led by Don Hall, including myself, Mimi Perka, who joined us in November and has already proved herself to be a great asset. Barrie Beaty, who you all know, Mead Spots, Greg Habib, and Ralston King, all of us working together down at the General Assembly to ensure that we get some great results for the dealers out there.
Hey, everyone.
And with that, I'm going to turn it over to Mimi.
Yeah. Hey, everyone. I'm going to go through the warranty compensation bill that was just passed and signed by the governor. Just quickly, there are about 6 main things that we need to hit, and then we'll flip it over back to Ann. So as you all know, when a customer's vehicle has an issue that requires repair and the problem is not under warranty or recall, the customer pays the retail price. When a customer's vehicle has an issue that requires repair, the problem is under warranty and the customer pays nothing and the dealership fixes the problem and is reimbursed by the manufacturer. However, manufacturers manipulate the amounts paid for warranty and recall repairs. They manipulate that reimbursement in numerous ways. First, they do not pay the same hourly rate as retail customers. They often artificially reduce the amount of time the claim is required for warranty or recall labor, so they pay less hours back to the dealership. They also have complete control over the price of parts, and they often alter them to reduce their warranty or recall repair reimbursement costs. And all of this forces the dealership to either pay their technicians less for the work they do on warranty and recall repairs, or supplement their pay and allow the manufacturer to shift the cost of the product quality issues back to the dealer. So first, this bill removed the reasonable qualifier and relies on the statutory calculation to determine a retail amount. So Virginia code requires that manufacturer compensate dealers for the warranty work they do at the same amounts as dealers charge to retail customers. Prior to the 2025 legislation, manufacturers challenged the amounts that the dealer was claiming for reimbursement on the basis that the amounts were not reasonable. This bill brings Virginia in line with 15 other states and removes the reasonable qualifier so that the manufacturer can no longer state that the dealership shouldn't receive the reimbursement that they requested due to reasonableness. So it simply relies on the statutory calculation to determine the retail amount. Next, the bill guarantees that technicians are compensated for time spent waiting and communicating with the manufacturer for technical assistance related to a warranty or recall repair. As vehicle technology has advanced over the past couple years, dealers have witnessed an uptick in the time dealership techs are spending troubleshooting repairs with the manufacturers. And when that occurs, automotive technicians can't just simply move to another vehicle while they're waiting on an answer to solve the problem. So this bill should guarantee that the technicians are compensated for that time they spend waiting and communicating. Next, this bill addresses the problem of parts pricing manipulation by prohibiting manufacturers from arbitrarily reducing the price of a part that will be used in a recall or similar repair. The bill establishes that the price of the part is the highest price in the last 12 months. So as you all know, dealers are compensated for warranty and recall repairs, both for labor and parts. The parts compensation takes the form of a markup of a percentage of the price of the part, just like any other retailer. And manufacturers have routinely slashed the price of these parts for recall and similar repairs to slash that markup amount in order to pay dealers less for those repairs. So this bill will ensure that the price of those parts stays the highest in the last 12 months, so that dealerships are able to be reimbursed at that higher rate that they should be. Next, this bill allows the dealer to request reimbursement for rental expenses incurred with 30 days of dealer having paid those charges to a customer's rental vehicle. Dealers are often not reimbursed for the rental expenses until the repair is complete and the warranty claim is filed. When a customer drives a rental for an extended time before a warranty repair can be completed, the dealer carries a large expense. The bill also clarifies that the manufacturer must reimburse the dealer when it provides a rental without exceptions for the kind of vehicle. So the manufacturers do not always reimburse dealers according to the language of the statute. We've seen a manufacturer who has refused to reimburse dealers who are unable to rent the same line make, for example, of the vehicle that the customer has brought in, but they still require the dealership to provide a rental vehicle. So this bill clarifies that the dealership must be reimbursed for that rental vehicle without the exception of the line make or any other exception that the manufacturer might be stating that the dealership needs to comply with. The bill also allows dealers to return unused recall parts. So manufacturers often prohibit dealers from returning parts that dealers do not use related to recall or similar repairs, which leaves dealers with obsolete inventories. Dealers are then forced to either limit parts on hand to quickly fix their customers' vehicles, or they risk losing money on parts they can never use or return. So you all should be able to return these unused recall parts that are used for warranty or recall repairs.
Now I'm going to talk a little bit about buyer's orders for leases. The one thing that we put in place was a recognition in the statute that buyer's orders for leases should have some different terminology. If you look at that statute, it talks about buyer, it talks about sale price, it talks about lots of terms that relate to a sale versus a lease. So we just clarify that the lease terms that are more appropriate for a lease transaction are also permitted on the buyer's order. And most importantly, what we did was include similar spot delivery language for a lease, for a buyer's order for lease that we have in the code. And just as an aside on that, one of the things that we've done as part of this statute is we have done a pretty broad revision of our Virginia buyer's orders themselves. It's going to look like a substantially different form. There will be an option to have a lease form. It is an optional form. You can still use the other standard buyer's order if you want to continue to do so. Barrie and I recorded a training video that is available on our website, and you should see Reynolds and Reynolds rolling out these new forms. One of the biggest things about these new forms is it's really an opportunity for all of us to sort of reset the buyer's order. We see a lot of buyer's orders out there that have been modified over the years, and some of those modifications are just, I mean, honestly, they're pretty ugly. So this just is a time for all of us to really get back in line with what we need to be doing with our forms. It has lots of great protections in there for you. And on that spot delivery issue in particular, one of the things we always like to point out to dealers is you do not need any sort of supplemental spot delivery form in your deal packets. The statutory language is all that's permitted, required, necessary. So if you have a supplemental delivery agreement of some sort in your standard deal packet, you need to get it out of there. It just doesn't need to be there. And the last couple of comments we'll make about the legislature is that, we're seeing a lot more sort of business type issues that are not necessarily dealer directed, whether it be fees in consumer transactions, fees charged for using electronic funds transfers, class action lawsuits. Some of these have been successful in certain places. We've been very successful in getting ourselves carved out of some of these kind of bills, but it just heightens the scrutiny of our industry and business in general that we're seeing as part of the General Assembly. So we just wanted to let you know that these things are happening out there, both these kind of consumer lawsuit things, but then also as employers, there have been lots of movement on things like minimum wage, which doesn't hit our industry as huge as some others. Things like salary history requirements, requiring that you post a salary range or a salary when you're posting a job, whether you're going to be required to provide either paid or unpaid leave, which can also be, disruptive to your organization. So again, we're looking at more, not less of these kind of things over the next several sessions, and just want you to start thinking about that as you're looking at your personnel practices, as you're looking at your business practices, and just know that there's never been a time where the auto industry and business in general has been under more scrutiny. And so we just all need to be aware of that as we go about running those businesses. And then lastly, we would be remiss if we didn't put a plug in for our PAC. Many of you have been longstanding contributors. It doesn't, buy votes. It doesn't necessarily buy access, but it certainly lets our legislators know that this industry is important in Virginia, and gives us the ability to work with those legislators on all sorts of issues that affect you and your business. And with that, I'm going to turn things over to Barrie to talk about some federal and state enforcement issues.
Good morning, everybody. Thanks for having me. So this is our triage of kind of what we are going to go through on these enforcement issues, advertising. It is what the FTC is looking for and to avoid that, but it's really Virginia law also. The Motor Vehicle Dealer Board has put out a memo, or kind of hey, we're going to be looking at advertising more. And just so everyone's aware, when we talk about advertising in this webinar, it is for Virginia only. It does not cover any other states for which dealers may have stores. There are nuances in each state, and this webinar does cover predominantly only Virginia. Selling practices, that kind of goes with the advertisement, and also your F&I practices, such as you cannot tie a price of a vehicle to, entering into getting certain products or things of that nature. And getting, compliance with the equal credit opportunity, the sales of add-on products, the new safeguard rule, which you guys all have been doing for almost 2 years now, and making sure that you are in compliance with that. It's quite extensive. Credit reports, there's always people, customers really, I didn't allow you to do that. Why did you send my credit report? So, what is your policy on credit reports? And the used car rule. And you're probably wondering, why are we discussing the used car rule? Unfortunately, it's still an issue with the form. The buyer's guide is not easy. So we just kind of rehash it in these webinars. So with that, I'm going to move to the first advertising point we're going to make, which everyone knows about and we've covered several times over, but it's your TILA and CLA requirements. essentially, if you advertise a trigger form under those acts, you must do the follow-on disclosures. And most dealers do know this. Most dealers are doing this, but sometimes, you forget to you advertise one of those trigger terms, and then you do forget to do the follow-on disclosure. This is the easiest advertising rule out there. It is easy to find for regulators. So I highly suggest with this webinar, there are checklists that my firm has provided. It's right there. So if it's very easy to file on the checklist. If you have a trigger term, make sure you have the follow-on disclosures. And in this webinar, by the way, in we're going to get to it in the next couple slides, there are the guidance as well. And we will go through this quickly. So covering one of the consent orders that were entered into during the Biden administration. And I'm just going to talk a little bit about the FTC right now, because you're probably wondering, well, it's the Trump administration and federal government is being scaled down. The FTC is still there, still operating. Okay. As of right now, President Trump did get rid of 2 of the Democratic holdovers from the Biden administration. So right now there are only 3 commissioners. Andrew Ferguson is the chair, and then 2 other Republican commissioners. Lena Khan is gone. She was quite the zealot in enforcing a lot of things, including trying to get the CARS rules passed, which all of you know is now gone. Okay. With that being said, one thing that the FTC has said is they are going to not investigate disparate impact, which was a lot of the consent orders were entered into. They're not truly going to focus on disparate impact. But what they are going to really focus on, and they are not giving up on this, is Section 5 of the Act, which is advertising and deceptive practices. So they will continue to go after dealers if they see advertising issues and deceptive practices. Okay. And Andrew Ferguson, chair commissioner, has notified the NADA on that. Okay. So one of the topics in this webinar is heavily on advertising. Mr. Coulter had a very small store. He reached a settlement with the FTC, and he had advertising issues, and then there was a disparate impact claim. Okay. He settled with the FTC in the amount of $2.6 million. However, that's not the biggest issue that Mr. Coulter had. He entered into a consent order, and I always talk about the consent orders because they're quite extensive. And in his case, consent orders coming down from the FTC all looked like the CARS rule. So Mr. Coulter's consent order that he entered into is truly the CARS rule. He is not on this equal playing field of all his competitors. Okay. And that is a big thing with these FTC consent orders. They want to use the consent orders to kind of, when they can't do the regulations. So in the CARS rule, Fifth Circuit, which is actually out of Texas, ruled that FTC did not properly follow the regulations to make the rule, and they're not appealing that. And for that reason, that rule has not come back. It could come back in the later, in a future presidential administration. It will not come back in this administration. But he is under the CARS rule that requires him to put his processing fee in his advertised price. Okay. So I mentioned this because, again, the FTC is still going to go after those advertising violations. And so people need to be aware of advertising. So I'm going to move to the next couple slides. These are your TILA and CLA kind of rehashing of advertisement rules. And so if you have any of the trigger terms, you do the follow-on disclosures and what you are and are not allowed to put into these TILA and CLA advertisements. Okay. And these are just, you can read these, but you need to follow them and you need to have them in your advertisement. The next section is truly the golden rule. Okay. Do not advertise a price that you do not plan to honor. Okay. As of right now, there's certain things going on with tariffs, which we will talk about in a little bit. There are certain hot models of vehicles for which they are going over MSRP. in the case, if that's the case, such as you have a hot model, you want to, you want to meet your advertising requirements from your manufacturer. So you put the MSRP and then you say call for price, just so you know that defaults, the MSRP is then your default price. Okay. So if you are not planning to uh, sell a vehicle at that MSRP price, do not put it on your website. Whatever you put on your website is what you should be planning to honor when that person walks in your dealership. Okay. And so we're going to now move to advertising with the tariffs. This is a big thing and there's lots of questions on it. Now, we know of one manufacturer that has notified the dealers that it's going to go into the invoice price. And then that could add, make the invoice and the MSRP almost equal. Okay. Now, um, the NADA has issued a warning to dealers on this, and we have followed up and also issued a warning. I think that went out last month. Is that right, Ann?
Yes, I believe so. Yeah.
Okay. Now, if you plan on adding anything for that tariff to that MSRP, you need to put that on an addendum sticker. Okay. And you should have it on your advertisement. So it would be it would say tariff, and then you would put that additional amount, because otherwise you're going to be considered a bait and switch.
Well, and Barry, I would also chime in and say you need to be really careful on what you call it too. I mean, if the manufacturer has not communicated directly to you that they are adding, $1,253 on the car because of a tariff, you calling it a tariff could even be misleading. So just be aware that, the easiest thing to do is just put it in as an addendum sticker.
Right.
And you don't have to call it tariff. You don't have, you can call it market adjustment, you call it whatever you want, or call it nothing. Just say, this is an additional dealer, charge, and here's your price inclusive of that charge. So again,
Right.
be really careful when we're talking about these tariffs that you're not implying that, some $10,000 market adjustment is because of tariffs when it's really not.
Right. You need to have full disclosure to the customer as to what they are paying for. Okay. And next thing, this is big because this was kind of the way it was. It's still allowed in Virginia. But the FTC and even the Motor Vehicle Dealer Board has put out a little guidance that doesn't clarify this issue. We know all the manufacturers provide rebates, okay? And a lot of dealers will take the rebates and put it in their price and say, this is our price. The problem with that is a lot of dealers, you need to show the math, okay? And on top of that, the new rule, especially with the FTC and especially with the Motor Vehicle Dealer Board, was, well, all those rebates going in need to be available to everyone. Okay. And then it's sitting there going, well, is this available to everyone? Well, they could meet it. They couldn't meet it. The truth of the matter is the best practice is the next advertisement I have created. So everyone who's been on our webinars for however many years, 10 years or so, we use the Model T Motor Vehicle Dealer Board advertisement requirement. Okay. And it would have the price, it would have MSRP, then it would have the incentives and showing the math. Okay. And it was an old Model T, and the Motor Vehicle Dealer Board still uses this in their quarterly newsletter. I took that because even in the guidance of the Motor Vehicle Dealer Board and the FTC, that advertisement no longer truly applied. Okay. And so what I did was I made a sample compliant advertisement for what they truly want, because what the FTC wants is something that is not deceptive, and same with the Motor Vehicle Dealer Board. So I'm going to walk you through a little bit of this advertisement, and I kind of put down here your disclosures at the bottom, and then at the top underneath the car is your math box. And I realized that me putting this on a Word document is not the same And I know you all have constraints and logistics issues with the Mac boxes, but this day and age, it's really truly adherent that dealers need to get with their advertising companies and see what they can do. Okay. So just to walk you through it, it has the MSRP and then it has a dealer discount. And this is whatever you're getting. It may include freight. Okay. In Virginia, you may include the freight for the dealer discount. It may also include, you're getting some floor plan credits or whatever. You don't need to tell the customer. It just is what you're going to discount the car. And then you have the dealer's price. That dealer's price needs to say it does not include taxes, title, and tag, freight or processing fee, and whatever your processing fee is in the state of Virginia. That freight box, that freight, I have kind of done in a light blue, and I did it in a light blue because it should be clickable and it should open to another window. If you have removed freight in the state of Virginia, which you are permitted to do, you still need to have each model amount for freight. It cannot be a range. It cannot be a general amount. Freight may be up to $2,000. No, it has to have, if this is it looks like a Tesla, and we'll use Tesla because I know there's no Tesla dealers on here. It's a Tesla model. That freight exact amount needs to be there. Okay. Then underneath it, so your dealer price actually doesn't include those rebates that are specific, which is the military discount, possible first-time buyer, college grad discount, and at the time, which most likely will be going away, is the EV credit. Okay. And those possible discounts, you have a disclosure for those at the bottom, which you see on this advertisement, and then it has the amounts that the person could subtract from your price. But that price right there is available to everyone, and then they do additional subtraction. And if we go to the next slide, next couple slides are some critical points, okay? And I've kind of walked you through it so we can skip over these a little bit. So the bottom line is the incentives that some dealers do add but don't show the math. Those are optional incentives, additional prices for which come off your dealer discount. The purposes of itemization is the bottom line price, and the total savings should not include any incentives that cannot be included together. Okay. And that's always been the price. First time buyer with loyal. Okay. You cannot have the same incentives together. And the reason why we've changed these advertisements again is to really comply with the motor vehicle dealer guidance, which is an advertised price available to everyone, and the FTC. Some other critical points about advertising. There is no such thing as geographical pricing. So you have a price, dealer price for those living in my PMA. That's not correct. It is a dealer price to everyone. There is no such thing as an internet price. If you have, internet prices, $25,000. There's no such thing as an internet price. So that when someone walks into the dealership and they don't mention the internet price, the vehicle is actually at $30,000. That is not true. And that is not an actual, way to advertise. Okay. That's actually deceptive and under the FTC and the Motor Vehicle Dealer Board. Okay. And again, another key point is if you had add-ons on that vehicle, you put something on the vehicle, such as let's say a bed liner for a F-150 truck. If you put that already in there and it's already on the truck, that needs to be put into the advertisement up in the top box, added to the price. Okay, so that person coming in isn't like, well, I don't want it and I didn't know it was in there and I'm not paying for it. Okay, you can't add it after the fact. Next slide, we're going to go to, this is a big one in the state of Virginia. Under the buyer's order statute, there's very key that there are only a few fees that are allowed to be added. Okay. It is the processing fee and any pass-through electronic titling fee. There's no reconditioning fee. There's no record creation fee. and other fees that are not allowed by law. Okay, Virginia is very, very keen, and because we do not have, I will get to the processing fee slide in a minute. There's only a few fees allowed. If you are adding other fees, commission fees and the like, those are invalid under the state of Virginia and will cause problems. They are not permitted. It is grounds for a motor vehicle dealer board complaint. It's also grounds for an FTC complaint. Okay. This is a big one. Third-party sites. I put this in here because it is on third-party sites, you cannot control the advertising like you can on your own. Okay. And you are entering the information on the third-party sites, but it's in their platform. For that reason, not everything translates the same. And a big thing that does not always translate the same is my concern for dealers has been when you change pricing on your website, sometimes due to markets, for example, a used vehicle may change 3 or 4 times, if not more, in a daily basis. Okay. On the third-party sites, that change sometimes does not happen instantaneous like your site, and it could be lagging. Okay. You might also not be able to do your disclosures and disclaimers. You need to really pay attention to the third-party sites, how you're advertising on it, and what you're putting into those third-party sites. Okay. That way you are compliant on all platforms for which you are advertising. This is cars.com, thecargurus.com, and you need to know what those sites may say. Excuse me. Someone may be going to those sites rather than your website and finding a price that actually is not up to date. And the next slide is the processing fee slide. This slide has been in here for many years. You are very lucky in the state of Virginia because you do not have a cap. Some states have a cap, one of which is Maryland. This privilege should not be abused. Okay, there is VADA has always put out a pamphlet for which the processing fee says what it is for. It is not used. It allows you to tell the customer this is what the processing fee is for. It is voluntary. It is not a requirement. And because you have this very wide privilege in the state of Virginia, you should not be using other fees to also add to your bottom line. That is the sales compensation fee, a reconditioning fee, and transportation fees not permitted under the state of Virginia. There is the Motor Vehicle Dealer Board has said that you can have a transfer fee for limited purposes. And that's from your one dealership to another. And I believe it was around, I don't know if they set an amount, and I don't think they set an amount.
No, I mean, basically what they were looking at is, I call that the CarMax rule. If you go on CarMax's website, they say it's, $600 to ship it from their store in Nevada. And that $600 is payable whether you buy the car or not. So that was sort of the trigger for them. It wasn't just a way to add to the sale price. It was really compensation for transporting that vehicle. And so that was where that came from. But the dealer board has opined on several of those fees, and they are just not permitted, period, under the administrative positions that the dealer board has taken. And so when you go to your 20 group meetings and somebody comes up with a great idea on some fee, just understand that, that creativity is not gonna end well for some dealer somewhere along the way. It may not be you, but it very well could be. So just be aware of that.
And just remember not to abuse your rights under Virginia to have that processing fee. Next slide is another FTC summer of 2024. They, almost a year ago, they put out their guides for concerning endorsements and testimonials and advertising. It's almost a, I call this like common sense rule. So they want your reviews to be bona fide reviews, essentially. They don't want you paying, if you've paid for your reviews, you have to say it in the review. They want to actually have purchasers who have purchased your product in the reviews. Now, as I understand it, on Google and some of these other sites, you actually cannot erase any reviews. That was a big thing, not to distort or, distort or change or, remove them. As I understand it, that's it's virtually impossible. You cannot do it. However, it needs to be disclosed if the customer is incentivized, and or let's say a family member who truly didn't purchase the vehicle, and that does need to be disclosed. It needs to be a bona fide purchaser. Okay. Essentially, do not distort your reviews. Fair lending policy. This has, always been the case. You should have a fair lending policy. The NADA has developed the best one out there. It is very thorough. Your F&I department should be using it. This is the dealer participation certification form. This should be in every deal file for which F&I you're doing the lending. You're finding the lenders for the customers, and why there is a deviation. This should be in there. Okay. If there is no deviation, it should be in there. This should be in every deal file. Okay. And this is the Appendix D of that policy. You would create your own sample form, and it should be used. And this is why there was a deviation, and it should be enforced. If it's not in your deal files, why are you not using it? And this prevents you from having a discrimination claim. Okay. Or I shouldn't say prevent you, but if there was ever a discrimination claim, you go through it and say, obviously not there's no discrimination here. This is the reason why. The VPP policy is the same as fair lending. Why is there deviations for VPP products? The NADA has also put out a policy and program for VPP products. It also has a deviation page for VPPs. I highly recommend that as well. There are several reasons why there's deviations for financing and VPPs, okay? And all of which are not discriminatory. Some person has a bottom line price that they will pay, and how did you get there? Okay, and that's one of the reasons why you deviated. F&I personnel should be using those products, should be using those policies, and you should be enforcing them. These are key selling practice issues. Okay, price of the vehicle is not tied to any financing or option of product purchases. You should be using a menu of the products. Each price of those products should be displayed on that menu. That person should be deciding on the menu what they want and what they don't want. A big thing for the FTC is that the products are beneficial to a consumer, that they are actually getting the benefit of those products. And then do not misrepresent material facts to induce signing of the menu or buying products that that the person does not want. So such as you require them to do financing through you, they can refinance later. Lender requires this product. So those misrepresentations are also violations under the Fair FTC Act. Refunds for cancellations. This is kind of a big one when it comes to, you're getting chargebacks on a monthly basis. I note this because dealers need to understand with their finance sources what is happening with those chargebacks. Okay, so if someone comes in and is canceling products on a car that still has a loan, the bank will most likely credit that customer the loan amount. They will not receive a check. They're going to get a credit in that loan amount. And then if you pay off the loan amount, you're still, basically the person is getting the credit through the loan amount. If you give the chargeback credit at the time of a trade and you're paying off the loan for which the dealer has now been credited the loan amount for the chargeback, the customer's getting a double chargeback. Okay, it is on the dealers to figure out how exactly the banks are handling these chargebacks, because you don't want to be sending the customer a check or giving them a reduced amount if the bank is also going to be doing it. Okay, and this is key for dealers, and to know who's getting what on these chargebacks, because you may be double paying on these chargebacks. And do you have anything to add on that?
No, I mean, it's just, it's an area where we have seen some, a little bit back and forth with different lenders, uh, doing things in different ways. And sometimes the dealer ends up on the short end of the stick with a, chargeback for a refund that they've already credited to the customer. We're actually doing a little looking at this to see if there's a way we can, sort of help just the industry in general come up with a more streamlined process so that everybody's doing things sort of the same way, so that dealers aren't the ones caught, left holding the bag.
Right.
If they've tried to help their customer by giving that refund, applying it to a new transaction, and then, oh, by the way, the bank then sends them a check and charges the dealer back, so the customer gets paid twice. So we're looking at that now. A lot of this happened because, the banks were getting hit with, settlement claims from regulators because these weren't being done, 15 years ago the way they were supposed to. So it's an evolving issue. More to come on that, certainly from our end.
And I just want to note, if you based on those being hit lawsuits against the banks, if you read a lot of your master agreements, it will most likely say the bank gives the credit to the customer.
Yeah, absolutely. I'm going to talk about a few more issues here. Barry mentioned accessing customer credit reports. I think all of us have had a lot of experience and know what the rules are. No, you don't technically have to have authorization, but man, it's awfully nice to have that signed authorization form. That's what you really need to do. Keep them for 5 years. The most asked question I get on this subject from dealers is, a customer comes in and said, you sent my application to all these different finance sources and now you've hurt my credit. That is an urban legend, an old wives' tale, whatever you want to call it. I always direct dealers to the credit bureau sites themselves, have a frequently asked question that debunks that. So if you ever got a customer that's coming in, as I like to say, madder than a wet cat about the fact that you sent their credit app to all sorts of different banks saying that you've somehow destroyed their credit. They don't have to believe you, but they can believe Equifax or Experian or TransUnion if you just pull up that frequently asked question. Just a little tidbit there. Next, let's talk a little bit about safeguards. You all have seen these slides over the years. Obviously, this is something that you were required to update how you did your safeguards. I go back to whenever this was put in place. Originally, it was sort of amusing because I'd go into dealerships and the first thing anybody would ever want to show me is how everything's locked up. So that was sort of the first iteration of Graham Leach Bliley and safeguards rules. We are 1,000 steps past that now. And if you look at all of these things that you're required to do under the safeguards rule, quite frankly, it is basically gotten to the point where the average dealer is not in a position to do all of these things themselves. We are very pleased to be partners with Comply Auto. They are a group that that is made up of folks that came from the dealership world. We work very closely with them. They have great systems for compliance, and this Safeguards Rule 1 is particularly good in that it does all of the things that you need it to do, particularly things like, monitoring your service providers. Well, once they know a service provider that works with thousands of dealers is compliant, each dealer doesn't have to do that certification. They've done it for you. So those are just a couple of ways that Comply Auto can really help you in this area. And like I said, we've almost gotten to the point where it's an awful lot to expect someone in your dealership to be doing this as a side part of their regular job. And it's really sort of time to call in reinforcements, call in the professionals, and use a vendor to help you. And we highly recommend Comply Auto for that purpose. Safeguards rule, obviously we all unfortunately became a lot more aware of data breaches and how all that works with the CDK kerfluffle last summer. One thing we would, point out under both FTC and particularly Virginia code, if encryption helps, we're talking about data breach notifications for unencrypted data under Virginia law. So if you are encrypting your data, you've got a lot of protection under state law. If you're following your Gramm-Leach-Bliley processes and safeguards rules processes, you've got a lot of protection under Virginia law. And also under that Virginia law, you have the right to know what records might have been compromised in a CDK type situation. So the long and short of it is, make sure your data is secured and encrypted, and that's going to go a long way to helping you comply with a lot of these safeguards rules and then data breach rules as well.
And can I just make one point?
Sure.
And again, on the safeguards rule, Anne is right. It is so comprehensive at this point. There really isn't someone in the dealerships that can handle all of it. And you truly do need a compliance company to meet all the requirements. One thing compliance companies do is audits of your dealership. So you do know where there are failures. It is incumbent on the dealerships when they get those audits to not sit on them. They need to actually fix the problem. So if you do get an audit from your compliance company, make sure you're fixing that problem, because otherwise, you're just letting the problem fester and that's an FTC violation, right? So you do need to look at what is going on, and if there is a problem, remedy it. And that's my only point on that one. So
Thanks. We're going to turn to the used car rule. Barry's right. We've been talking about this for a while now. And I am a bit of a broken record on this subject. This rule basically does not make sense for how to fill out this form that they revised. So you just got to memorize it and just do it properly. Remember under Virginia law that you're required to get that buyer's guide signed by your customer. And then also, importantly, understand how to fill out these boxes that, again, they don't make sense to what a customer is looking for, which is my vehicle covered by a warranty? They're not really as concerned as to who's doing it, but just understand how you're doing it, where to mark manufacturer warranty, where to mark dealer warranty. And then the last thing that we always want to point out with the used car rule is that buyer's guide is not sufficient. You have to have a warranty document as well. We have a sample, limited warranty document. If anyone needs one, just ping me and I can shoot it over to you. But that description on the buyer's guide of covered systems is not sufficient under federal MAGMOS warranty law. You have to have a separate document that lays out the terms of that warranty, and just want to make sure everyone understands that. With that, we're going to make a little switch to some franchise issues. And again, these probably are not unfamiliar to everyone, but it's always good when we're together on one of these webinars to have a bit of a refresher. We're still seeing a lot of activity and whether and how both the the CARB, the California Air Resources Board waiver, repeal to the federal tax credits going away. We'll see how all this sort of affects these issues. But right now we are still seeing OEMs pushing quite a bit for separate channels to distribute EVs, whether it's Hyundai and Amazon, which is not really sort of an EV issue, or whether it's a VW and Scout, or Honda and Afeela. We're still seeing manufacturers pushing to sort of try to emulate Tesla and their inexplicable stock price and doing direct sales. But remember, in Virginia, we led the way as the first in the nation to really address this concept of both agency and separate channels for EVs. And it limits very clearly what the manufacturers can do as it relates to what we would consider selling practices, some of them listed here on the screen. We want to make sure that dealers are the ones selling, that they don't make dealers just agents for EVs and or any other products that they might have coming down the pike. And we also made clear in our factory ownership statute that you can't circumvent the prohibition on factory ownership and those agency rules simply by setting up a subsidiary to do so. Anytime that a manufacturer owns more than 25% of a subsidiary, like in the case of Volkswagen and Scout, that's deemed to be them. You can't just say, well, I only, I own 50%, but it's a subsidiary. No, that's you. You can't just change your name and pretend it's something different. So just wanted to make sure that you're aware that we're, trying to stay ahead of the curve with our franchise laws. That doesn't mean that the manufacturers are going to follow them any more than they follow them when they're paying you for warranty or any other incentives they're paying you. So they're not self-enforcing, but at least the laws are on the books. The issue of allocations of these vehicles, initially we started out with dealers very concerned that they weren't going to be able to get the EVs that they wanted. Our code certainly provides some significant protections in that you shouldn't have to pay extra fees to get those EVs, nor should you have to, and then you're also entitled to your fair share of all the models your manufacturer is distributing. Now, it's also morphed into, well, what if I don't want some of those EVs? You also have the right to refuse to accept the delivery of any vehicles you didn't order. So the sort of flip sides of the same coin there, but know that when it comes to any of the allocations you have, be it EVs or otherwise, you've got some significant protections under Virginia law. Like I said, the OEMs are not just gonna roll over on these things. There's lots of machinations going on the state level to try to circumvent some of these rules. But dealers are going to have to enforce their rights either to prevent manufacturers from selling directly or to challenge the allocations they're getting on EVs, just like they would in any other case. And I know it's a huge frustration for dealers that the manufacturers don't just obey the law. I wish there was an easier solution to that. If anybody can solve that problem, I think they would be champion in a lot of corners, but it's just not as easy as we all like to think it is. And the example I always use is, I'm not sure about anybody else, but I'm not sure I voluntarily obeyed the speed limit in my entire trip to the office this morning. So most laws are not self-enforcing as a matter of course. With these franchise rights, though, hand in hand with your need to stand up for yourself is also understanding what you're agreeing to when your manufacturer is asking you to sign agreements. We have dealers that send us items all the time. Our code requires that that any agreement that affects the rights, duties, and obligations under your franchise has to be reviewed by our DMV. So that's a great way to sort of make sure that the manufacturer can slow down the process if they're putting the hard press on you to sign something and you want some more time to review. That can sort of operate as a little bit of a brake on a runaway process. But just understand that if you're signing a document that's specific to you, you may be waiving some of those rights under state law. So you need to make sure you understand what you're agreeing to on expenditures. Is it worth it? What rights are you giving up? We have a franchise agreement checklist that'll be in the link to the materials for this webinar. We highly suggest that you use that. But just be aware that your manufacturer may be asking you to sign things that do significantly affect your rights. We're always very glad to help sort of sort through those things with you. We can't give legal advice, but we can certainly review contracts generally that are presented to dealers broadly and make sure that the manufacturers are complying with Virginia law. Over the air upgrades, we've talked a lot about this over time. Just understand that you've got some significant protections under Virginia code where your service department and your text time is being used to help a customer with an over-the-air update. You are entitled to compensation for that. So make sure that you're aware of that and that your manufacturer is paying you for any time that you're assisting customers with those issues. We still get lots of questions about facilities upgrades and de-dueling and how this all works. Understand that you do have protection under Virginia law for upgrades that you have done at the request of the manufacturer in the last 10 years. So again, making sure that you know what that protection affords you. It doesn't afford you protection from any upgrades. It's just something you're being asked essentially to redo. So make sure that you understand that when you're looking at facilities upgrades. There's also significant protections from having to remove different franchises from your facilities. I'll ask Barrie to chime in a little bit with how this may impact buy sells. It certainly is a challenge, but there is some statutory provisions that provide some leverage in buy sell transactions because of the buyer can't be asked to do anything the seller couldn't be asked to do as far as upgrades go. It's the enforcement mechanism that can get a little bit more challenging. But I know, Barrie, you've seen a lot of this in the buy-sell arena, manufacturers taking that opportunity to try to wrest a facilities upgrade or facilities changes from buyers.
Absolutely. So, especially during the buy sell, if it's a really old facility, it's a little, it's a hard argument. But one of the things that has happened in buy sells is a condition of the buy sell and the approval of the buyer has come on the heels that the buyer will upgrade. Let's say the facility is only 5 years old and the new program came out. And they're like, well, you need to upgrade the facility or you need to de-dual to get the money. The buyer in the state of Virginia has the same rights as the seller. So you cannot be asked as a buyer to do a condition that the seller cannot do. So essentially you step into their shoes. There is a buyer's right statute in Virginia during buy sells. It's 1569 3A, I believe, that has been added. And it gives the buyer rights to say, hey, you couldn't ask this of the seller, you can't ask this of me. And it prevents a buyer from getting a conditional approval to say, yes, manufacturer comes, I'll approve you if in 3 years you move the facility to de-dual it and you upgrade it to this new program, even though you are buying and you're actually paying for a 5-year facility because you're paying for all the fixed assets that the seller has done. You're paying for a new facility that's in your blue sky. I mean, the buyer will essentially be paying for double what they should be paying for when they have to move it and everything else. So the buyer has rights in Virginia where you're stepping into the shoes of the seller, and the manufacturer cannot be asking conditions of the buyer that it could not ask of the seller. That's essentially what the statute is. And there are some manufacturers, as you can imagine, that have tried to push this along for buyers, for which we have had the fights about it. And a lot of it is the buyer standing its ground, because also, if you recall from last year, we beefed up the rights to denial in the state of Virginia. So not only do we beef up the rights beefed up the rights of buy sells and the limitations of denials in the state of Virginia. And then obviously there's this condition. So really buy sells, we've tried to limit this ability of the manufacturers to deny a buyer essentially if they're not going to build them a new facility. So, but it is a significant protection for both the selling dealer for the asset that they're selling and the buying dealer so that they're not paying double.
Absolutely. And I think that does additionally, bring up a great point, which is sometimes, these franchise laws work best, and not sometimes, most of the time, these franchise laws work best because they give an individual dealer leverage in their individual situation to get a result that is more satisfactory to them than what the manufacturer would be willing to do without these laws. So again, may not be these broad sweeping, courtroom drama sort of cases involving these franchise laws, but understand that you can use these franchise laws surgically to make sure that you are getting the best result in any dispute with your manufacturer that you may have. If you ever have any questions about any particular issue you're having, please feel free to reach out to us. That's why we're here. But again, all of these little, very detailed code provisions can provide a lot of ammunition and a lot of leverage for you in working out any conflict you may be having with your manufacturer. And it doesn't all have to result in, some big administrative hearing or court case. A lot of these things get worked out because you know your rights and the manufacturer knows you know your rights. So just keep that in mind.
The manufacturer is going to push and push and push until you push back a little bit. Okay. They want everything under the sun, whether they're allowed to do it or not. And if you don't push back, they're going to get their way. A little bit of a pushback using, and it can be done strategically. Again, Anne's right. It does not need to be a administrative hearing. It doesn't need to be a courtroom drama. There are some strategic moves you can make to really enforce your rights in the most business-like manner to keep that relationship going.
A couple of real quick franchise issues to sort of finish out this part of our webinar today. Changes in ownership. Make sure that you're providing the manufacturer any changes in ownership. And this usually comes up where it's a small gift that you give and you think, oh, it's 1% or it's 5%. And you don't think about the fact that the manufacturer does need to get notice of that. And then also if you're doing any estate planning and putting things in trust, that is also considered a change of ownership. So just make sure you're on top of notifying your franchisor of those changes that you may be making. We still obviously see a lot of conflict with manufacturers and dealers over performance claims, whether it's sales effectiveness or CSI. A lot of these sorts of claims, you need to make sure that you are understanding what some of the root causes may be and challenging those, whether it's your allocations or your PMA. CSI, make sure that you're looking for that statistical sufficiency of how they're measuring you. We always make sure that dealers know that those performance standards have to be fair, reasonable, and equitable, which are all really, really lawyerly words that you can spend a lot of time fighting over. But you can challenge any of those measurements. PMA is a great example where just geographic settlement patterns, things that the newly minted MBAs up at Urban Sciences don't always understand, that people don't drive across that mountain or people don't cross that river in my community. That's just not the way things work. So make sure you're challenging those things, and also just make sure that you are not just putting those letters in a drawer somewhere because you think they're just wrong about my PMA. Well, let them know that, so that 3 years down the road they don't say, well, we sent you these 4 letters and you never responded, and now they're sending you a termination notice. Again, you've got very significant protections, so even a termination notice is not as dire as it sounds, but just know that, you know, making sure that you're addressing those communications from your manufacturer when you see them, and challenging the bases for which they're making their claims about, you know, insufficient performance on the dealership's part. Indemnification, you've got some provisions in your sales and service agreements that that indemnify you for certain product problems. This is particularly important if you're ever get dragged into a lawsuit. You know, you can get out of it with that indemnification provision. But then also, you know, if you go to sell a store, make sure that you're not releasing those indemnification obligations, because they may pop up years later. So you want to make sure that you maintain that protection. And then lastly, succession. Obviously, the franchisors are concerned about, you know, control of the dealership. Going forward, they're much more aggressive about having succession plans in place. Understand that you have significant protections in being able to name a family member, and that includes that definition of family member includes, you know, a longtime manager, somebody who's been with you for more than 5 years. Those folks get quite a bit of protection in being able to be named a successor. So not only is it a great idea to have that succession planning just for your own peace of mind, but the manufacturers are very interested in making sure those plans are in place. So make sure that you're doing that as part of any of your financial and estate planning, and letting the manufacturers know what those plans are. And with that, I'm going to turn it over to me.
Can I make one point
Yep,
before we move on,
absolutely.
Ian? Okay, I always want to make this point for the dealers when it comes to franchises. Should you receive something from your manufacturer, you know, we're going to sign a renewal of your dealer sales and service agreement. Oh, you didn't sign the renewal by this date, you know, you're gonna not have your dealer sales and service agreement. I always like to remind dealers, your dealer sales and service agreement never terminates until you have truly been terminated. And you had triggered this, you know, Anne, when you said it, truly been terminated and gone through the hearing. Okay, you have the right to, if you get a termination notice, that is the only way your sales and service agreement is terminated. You may voluntarily terminate it, but other than that, I mean, they need to actually terminate you. There is no expiration date on those sales and service agreements. Okay, so it expires in 5 years. There's no such thing in the state of Virginia. Okay, so just so you remember that, they cannot force you into some renewal that is actually in opposite to how you've done business for the last 50 years.
And they certainly can't use that termination date in their own contract to say, you've got to sign this.
Right.
And oh, by the way, we've included some individual terms for you that might not be great. So again, you've got the standard part of your dealer sales and service agreements, but there is part of that sales and service agreement that is related to your dealership. And it can include things like, you know, capitalization,
Facility upgrade
all
requirements.
sorts of things. And if they're putting pressure on you to say, you've got to sign by this date or your agreement expires, that is an empty threat, and you should not be pressured by it. Full stop.
And that's those slides few back where Ann said, be careful what you're signing and know what you're signing. Those are those addendums to the standard agreement that they're stacking in those renewals. Okay, so just be careful when you sign those renewals, because you got to remember that sales and service agreement, you can still be on the one from 50 years ago. So
absolutely. Like I said, we're going to turn to Mimi for some little bit of personnel issues.
Yep, so I think none of this is completely new, but some of it's a little bit new. So these are just some reminders on some personnel practices. First, a reminder that Congress passed the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021, which was signed into law in 2022. You should review your arbitration agreements to make sure that they do not cover any sexual harassment or sexual assault claims brought against your dealership by an employee after March 3rd, 2022. So you can't force an employee to arbitrate a claim of sexual assault or sexual harassment. So you just need to make sure that that's no longer in your arbitration agreement. This is important in this administration. So the Immigration Reform and Control Act mandates that employers verify employment eligibility of all employees hired after November 6, 1986. Employers must complete the I-9 form for each employee, which verifies their identity and authorization to work in the United States. You need to make sure that you're using the current I-9 form. The dealership must complete the I-9 form for every person hired within 3 business days of the hire. The employee must complete section 1 of the I-9, but the dealers are responsible to ensure that the employee fully and properly completed the section 1. So that's twofold. The employee needs to complete section 1, but the dealer is responsible to ensure that that was completed properly by the employee. That section 1 needs to be completed no later than the first day of employment. Employees have the right to choose the document or documents that they provide to prove their identity and their right to work. If an employee can't present the required documents within the 3 business days of employment, and the employee stated that they applied for the appropriate documents, and the employee must give you a receipt for the application within those 3 business days. Dealers should retain the I-9 forms, the completed I-9 forms for each employee for 3 years after the employee's employment begins, or 1 year after the employment is terminated, whichever comes at a later date. The best practice for this is to conduct routine internal audits of your personnel I-9 form and the records, so that you can identify and rectify any discrepancies or issues in the documents or in the retention of the records. The Pregnant Workers Fairness Act went into effect in 2023, and this requires employers here, meaning those with 15 or more employees. This requires those employers to provide reasonable accommodations to workers' known limitations related to pregnancy, childbirth, or related medical conditions, unless the accommodation will cause the employer an undue hardship. These went into effect in June 2024. And the accommodations here are really achievable. Some examples of these reasonable accommodations would be breaks for the employee to go to the restroom, offering equipment to assist that employee with lifting or carrying, temporarily suspending one or more essential functions of that employee's position, giving that employee breaks and a space other than the restroom for pumping or breastfeeding, or providing reserved parking spaces close to the dealership for that employee to park. Whatever the accommodation that the employee's requesting, it just has to be, the dealership should be providing accommodations that are reasonable. And these are some examples of those. And then lastly, Retire Path. Retire Path was created by Virginia's state law to expand access to retirement savings. So Virginia employers are required to register and facilitate Retire Path if they have 25 or more eligible employees, they've been operating for 2 or more years, and if they do not already offer a qualified employer-sponsored retirement plan. So if this is you and you are eligible, yeah, you should be signed up for the Retire Path program.
And with that, I think we do have a little bit of time for questions if I can figure out how to get those off of chat or wherever. I don't see any.
Ely has a question in.
Let's see here. Where are you seeing that, Barry?
Q&A on the bottom of the webinar. Do you have a little box under the
Oh,
bottom?
wait. Yeah, I see. Hold on. Got it.
Okay.
FTC buyer's guides, if you're giving a used 12-month 12K that you pay through a third party, you still mark as is, no dealer warranty. So it's the dealership is paying for it, but it's being provided by a service contract company, do you still mark as is? So it's a service contract or warranty? And that's, maybe that'll be a follow-up. We can certainly ask him.
It's
12
a 12.
Thanks, Ely. Uh, I mean, that's a dealer warranty, isn't it, Barry?
Yes,
It doesn't
I look at that
matter.
as a dealer warranty. You're
It doesn't,
paying for it
yeah,
and
you're
giving it to
providing it.
them.
Yeah, you're giving it. In a point of fact, most dealers are providing some sort of product through a third party as their warranty. A lot of dealers are. You're sort of, it's not reinsuring, but it's something akin to that, where you're essentially selling an extended warranty, uh, or you're providing an extended warranty through a company. You know, that should be something that's a dealer warranty, and you have to provide the document there as well. Got another question here. One of our digital companies does have the ability to show a discounted price when somebody clicks on get internet price. Is this allowed? Again, the problem becomes, the problem is a practical one. So the regulator comes in and says, here is the price that you offered as your internet price, whether it's because they clicked on discounted or whatever. Here is that vehicle, particularly new vehicles. Say you advertise, you know, a new car at 25,000, you had this special discount that they can click on and make it 23. You sold all the cars at 25 because nobody clicked on it or nobody told you. The only most logical explanation for that is that you never intended to sell it to anybody for 23, and that's what they're going to claim. So that's where it gets very complicated, because it's a question of how do you show that to a regulator that comes in and says, you advertised 23 on this special little click, but then you sold the car for 25 because the person either didn't know. It's just a dangerous place to be. Is there a way to perhaps show that proof to a regulator in a way that satisfies them? Maybe somebody can. Boy, I wouldn't want to spend the time and money doing it, though.
And the real problem is, I'm assuming one of the things in the cars rule that was really an issue was keeping all the advertisements and going through that. You're not going to be able to keep all that data to show all that. It's really a slippery slope when it comes down to it, because you're going to have someone walk in and say, yeah, but I clicked it, actually sitting in the, you know, you're not giving me the advertised price and it's 23, you're telling me it's 25. Oh, now that you've clicked it, you know, here it is. It's really a slippery slope that you're walking. Whatever you're intending to sell the vehicle at is what it should be advertised at. And the internet, playing around with internet pricing like that is a slippery slope, because unless someone mentions it, you're not giving it to them, and then they're going to go home, click it, and say they've been defrauded by you.
Says we cannot offer $1,000 finance coupon if it's disclosed on the website. You can offer any discount that you want.
Right.
If it is conditional, you have to make sure you are clearly and conspicuously disclosing those conditions, and that those conditions are not discriminatory. You know, you can't say that I'm only going to provide this discount to, you know, women or men or whatever. But in point of fact, you can offer a finance discount. You can offer a, you know, whatever discount you want to. If there's a condition that a customer must meet to get it, you need to make sure that those conditions are fully, clearly, and conspicuously disclosed.
Let me tell you something. No one is going to argue when you're voluntarily reducing the price in the dealership. Okay. They're only going to argue when you voluntarily are putting things into the price and adding to it. Okay. The real issue comes when the adding to the price happens versus the disc. If you're going to say, hey, you know what, we actually have $1,000 off, they're not going to argue, well, that wasn't advertised, I don't want it. That's never going to happen. Okay. And you're never going to be found liable for that. I mean, you're giving the person money off versus from what it's advertised versus, you know, that's not really an issue that's going to be grounds for an FTC violation.
Great. Well, I don't see any more questions right now, so we're going to finish up our webinar here today. We're very pleased that all of you could join us. As always, if you have any questions, concerns about anything we've gone over today or anything that pops up, you see a QR code on the screen. We will be loading a recording of this. Our communications folks do a great job of sort of breaking down the recordings into different pieces as well. So look for that email coming out shortly. We hope to see a lot of you at the VADA convention next week. And hope that you all have a great remainder of your day. And if there's anything that we at VADA can do to assist you and your dealership, please don't hesitate to let us know. And with that, we will sign off. Thank you very much.
Thank you.